Today we're going to be discussing special education. In 1948, only 12% of all children with disabilities received some form of special education. By the early 1950s, special education services and programs were available in school districts, but often undesirable results occurred. For example, students in special education classes were considered unable to perform academic tasks. Consequently, they went to special schools or classes that focused on learning manual skills such as weaving and bead stringing. In 1975, U.S. Congress discovered that 8 million children in the United States had not been provided appropriate educational services that offered these children any type of public education opportunity, and over 1 million children with disabilities had not received any type of public education. In Special Education Part 1, you will learn about the early critical events that have shaped special education today, including statutes and cases. I will also review the established special education principles and required processes for children to participate. The critical event in early development of special education services were individuals and organizations that fought against the exclusion of retarded children in education, such as the Council for Exceptional Children starting in 1922, the Cuyahoga Council for Retarded Children in 1933, and the Association for Retarded Children in 1950. The national breakthrough for special education students was actually the landmark desegregation case of 1954, Brown versus Board of Education in Topeka, Kansas.
I was in my senior high school in an English class, and on May 17th, 1954, the gong sounded for the public address system, and the principal came on and said to us, Brown versus Board of Education has been decided, and in essence the schools will be desegregated. My English teacher stood for a second with a tear in her eye, and she said, now I can retire in peace.
Oh, I remember it was headlines in the Afro-American newspaper back in Baltimore. It was big news. I do remember that it was an issue that was talked about from time to time in school by the teachers, and so it was something that we knew about, something that we knew was important, and something that was hailed as a great thing.
I read it in the newspapers. I was in my second year of law school at the University of Washington Law School. I don't remember my constitutional law professor even discussing it. So I did not learn about the Brown decision from law school. I learned it from popular reading.
I remember my family, my mother and my father, talking about something I now recognize as Brown. I can't say I remember it as Brown, but it was quite a topic to talk about around the dinner table.
Brown is probably the classic case, other than Roe v. Wade, of the court making a strong and clear decision, even in contentious times. After Chief Justice Earl Warren was able to cobble together a unanimous decision, there were calls for his impeachment. There were death threats. There was a Southern Manifesto. The Southern congressmen said they would resist it by any means necessary. Governor Faubus in Arkansas stood in the door, wouldn't let black children come into Central High School. Governor Wallace said segregation today, segregation tomorrow, segregation forever.
And you know, the impact of it isn't so much its impact on school desegregation, where I think it hasn't been an overwhelming success, but more on how it spawned this whole movement to utilize the law for positive social change, and the way in which that sort of galvanized the civil rights movement and the women's rights movement and all of these other sort of major social change movements in the United States.
Well, it clearly was the case that ignited the modern civil rights movement, and so it opened up doors of opportunity not only in education but in the legal profession. And I do not believe that we would have as diverse a legal profession today if we didn't have the Brown decision.
My view of it was about bringing people together. And so I guess in that sense, now that you brought it up, it would be the fairness and the equal justice for people within the courts.
One of the most positive decisions ever made by the Supreme Court, and we need to celebrate its legacy, not just on the 50-year anniversary, but every year.
This ruling, the second critical event, opened up schoolhouse doors to black children, but also opened up educational opportunities for special education children as well. Chief Justice Earl Warren said, "In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, when the state has undertaken to provide it, is a right that must be available to all on equal terms." The third critical event for special education was two seminal district court cases. Pennsylvania Association of Retarded Citizens versus Commonwealth of Pennsylvania in 1972. This U.S. District Court ruling established that the state's children with mental retardation were entitled to a free public education and whenever possible should be educated in regular classrooms rather than being isolated from the normal school population. Mills versus Washington, D.C. Board of Education, in this particular U.S. District Court ruling, it was determined that no child eligible for public education in D.C. shall be excluded from a regular school assignment unless such child is provided adequate alternative educational services consistent with the child's needs, which may include special education and related services. Further, if the child is to be reassigned or provided other alternatives, procedural due process shall be required. Thus, this ruling became the forerunner to special education principles today. The fourth critical event in special education history was Congress passing two laws.
There were two laws that were enacted. In 1973, Section 504 of the Vocational Rehabilitation Act was enacted. And that was the civil rights movement sort of began to embrace the notion of people with disabilities. So that law was passed, and what it did was, it's a federal law that said that you can't discriminate against people who have a severe limitation on one or more major life activities. And the major life activity that we're concerned with in school is learning. So if people have a disability like that, an impairment, then if you take federal money, that what you have to do is be willing to accommodate, to make a reasonable accommodation for these kids to be in school. A really good way to think about Section 504 is a wheelchair ramp. So if you are able-minded but maybe not able-bodied, and if somebody can get you into a building and then you can do your job, or you can be a student and you can learn, then building a wheelchair ramp is that accommodation. That sort of levels a playing field for you. A lot of kids who have attention deficit disorder, a reasonable accommodation is some sort of a cubby, something around them. So for those kids who pay attention to everything, hopefully that reasonable accommodation will make it so the child can pay attention to the work in front of them. So we weren't yet at the point of talking about educating people with disabilities, children with disabilities, but we were talking about making it illegal to discriminate against them. So the education piece came in. Prior to 1975, if you could walk and talk and hear and see and had the capacity to learn, to read, write, and do math, you were welcome in public schools. But if you couldn't, then you weren't welcome. And parents either kept their children at home or they institutionalized them. And the same civil rights movement, they became aware of the need for the education of these children. So a lot of civil rights groups and a lot of parents filed suits, especially one in Pennsylvania, that said, okay, public school, I pay my taxes, why can't my kids go to school? And the Congress responded by enacting the Public Law 94-142, which is the Education of All Handicapped Children Act. So it's now, it's morphed into the Individuals with Disabilities Education Act, IDEA. But over the years, a lot has changed, not just the name. What I told you was this was a law that was enacted to bring more kids into schools. These kids with disabilities that hadn't been allowed in school before. But what happened is very interesting because Congress, when they passed the law, said, okay, states, okay, districts, here's what you need to do. You have to go off and you have to hire all these teachers, hire the evaluators, get the professional development, make space in all your schools. That's your job because these kids are coming. And then Congress said, and here's the commitment that we will make. We will provide, we will fully fund within 5 years this program. And by fully funding, what they meant was we will provide 40% of the national per pupil expenditure times the number of kids with disabilities, and we'll give you that much money over and above what you typically get. So you can see initially there was some incentive to identify children because your money that you received from the state was based on their head count. That's changed, but for the first probably 15 years, that was the way the money was allocated. The challenge is that 10 years after the law was enacted, the level of funding had increased to like 7.5%. Understand it was supposed to be 40. And so it increased to that much, and now it's up to maybe 18%, but it's never been fully funded. So what you have, which is words administrators hate to hear, is an unfunded mandate. You have to do this, but we haven't given you the money. And so that's sort of the evolution of it. So what happened is that kids started, it was supposed to be, let me be clear about one thing. The special education has only been enacted to provide a bridge for children to have access to the regular classroom. That's all special education is supposed to do. But what happened over the years is that we started with this one system. There's really only one system in school. And say what you will about No Child Left Behind, that certainly has made us focus on standards-based education and kids reaching the standards. But what happened, and I liken it to if you go into the housewares department of a store and you buy something that is like a vase, and it's a vase and it has like a price tag underneath, and very slowly, if you're very careful, you can peel away the price tag. So instead of just having a vase with a price tag on it, you have two separate things. And that's what happened in special education, is you had two very separate systems. The challenge there is that you can't teach kids something separately over here and think that they're going to be able to be tested on what's over here because they haven't had access to it. So that's what happened in terms of sort of understanding what went on in special education. And again, we lost sight of the fact that it's one system intended to be for all kids and intended for kids to have access to that.
So, the Vocational Rehabilitation Act of 1973 was the first act to address the notion of equal access of people with disabilities to work through the removal of architectural, employment, and transportation barriers. Section 504 of the law prohibited discrimination on the basis of physical or mental handicaps in programs receiving federal funds. The Education for All Handicapped Children Act of 1975, known as Public Law 94-142, set the stage for the particulars of special education in public schools as we know it today. The Education for All Handicapped Children Act established 6 principles. Free appropriate public education, or FAPE, guarantees that each child with a disability eligible for special education will be entitled to a free appropriate public education. Free means the education of each child with a disability must be provided at public expense with no cost to the child's parents. Appropriate means each child with a disability is entitled to an education that is appropriate for his or her needs. An appropriate education is determined on an individual basis. Public refers to the public school system for services. Children with disabilities, regardless of the nature or severity of their disabilities, have the same right to attend a public school as their non-disabled peers. Least restrictive environment is next, which guarantees that a child with a disability will receive free public education in the appropriate least restrictive environment. When considering special education placement, the team must explore the continuum of alternative placements from a regular classroom with supplementary aids to an isolated separate school such as a school for the blind. If the placement team determines that the student can be appropriately educated in a general education classroom using supplemental aids, this is least restrictive environment for that particular student. However, if the placement team determines that the student cannot be educated satisfactorily in the regular classroom, even with modifications and supplementary aids, the team must then consider other placements outside of the regular classroom. Thus, like all other components of a student's special education, the least restrictive environment must be determined for each student based upon that child's individual needs. The next principle is procedural safeguards, which are a set of activities whose purposes are to ensure that the rights of children with disabilities and their parents are protected, which include the right of the parents to inspect and review their child's educational records, be given prior written notice on matters relating to the identification, evaluation, or education placement of their child, and permit their child to remain in his or her present educational placement until administrative or judicial proceedings are resolved when necessary. Finally, as a safeguard, mediation and due process procedures must be in place to resolve disagreements between the school and parents. The law requires students be given an assessment to determine if the child has a disability and if he or she needs special education services. This required evaluation mandates that each student suspected of having a disability receive an evaluation in all areas of that suspected disability. The various components of the evaluation must be given by a team of evaluators who are knowledgeable and trained in the use of the tests and other evaluation materials that they use. This evaluation determines the child's eligibility for special education and related services, identifies the placement for services, and establishes the child's educational needs. Child Find mandates that students be located, identified, and provided services for all the students with disabilities within their school district boundaries. The last principle, parent participation, requires districts collaborate with parents in the development and delivery of their child's special education program. The Education for All Handicapped Children's Act prescribes the referral process for a student to receive special education services. First, the multidisciplinary team receives a student referral, typically from a teacher who notices the child is not performing satisfactorily in the class. The multidisciplinary team decides if a multi-factored assessment is necessary. The multidisciplinary team seeks parental permission to assess the student. After the multidisciplinary team receives consent from the parent, they must proceed with the multi-factored evaluation. The multidisciplinary team then conducts the battery of assessments. After the multidisciplinary team conducts the evaluation, they then determine if the child has a recognized disability.